The sound of someone pounding on your front door at 8 a.m. on a Saturday morning is never a good sign. When that someone is carrying a clipboard and wearing tennis whites like they're heading to Wimbledon instead of harassing neighbors, you know your peaceful weekend just became a battle for property rights and basic human dignity. My name is Jordan Mitchell, and I've been Cristiano Ronaldo's personal assistant and property manager for 2 years. In that time, I've handled everything from coordinating international business deals to managing his extensive real estate portfolio across 3 continents. But nothing in my experience had prepared me for dealing with a 35-year-old HOA president who thought lakefront property ownership came with mandatory membership in her personal fiefdom. Let me set the scene. Cristiano had just finished his European season and decided to spend some downtime at his lake house in Lake Tahoe, a stunning 8,000-square-foot retreat that sits on 12 acres of pristine waterfront property. The house had been in his portfolio for 3 years, purchased through a complex trust structure that provided privacy and tax benefits while maintaining his ownership rights. What we hadn't anticipated was Karen Whitmore. She appeared at our front door like some suburban harbinger of bureaucratic doom, wearing her signature white tennis outfit and gripping a clipboard with the intensity of someone who'd found their life's purpose in annoying successful people. Her blonde hair was pulled back in a ponytail so tight it could have been classified as a medical procedure, and her expression carried that particular blend of fake authority and barely contained hostility that screams HOA president. "Good morning," she announced through the door with the kind of volume that suggested she'd already decided we were going to be difficult. "I'm Karen Whitmore, president of the Crystal Lake Homeowners Association. I need to speak with the property owner about mandatory membership requirements." I opened the door with the professional smile I'd perfected for dealing with people who thought proximity to celebrities gave them special privileges. "Good morning, Ms. Whitmore. I'm Jordan Mitchell, property manager. How can I help you?" Her eyes immediately began scanning past me into the house, taking inventory like she was conducting some kind of inspection. "Mr. Mitchell, this property is located within the Crystal Lake HOA boundaries, which requires all homeowners to maintain active membership and comply with community standards. I'm sorry, but I think there's been some confusion. This property isn't part of any HOA. We received no disclosure of mandatory membership when the property was purchased." Karen's smile became predatory. "Mr. Mitchell, ignorance of community requirements doesn't exempt anyone from compliance. This entire lakefront area is governed by the Crystal Lake HOA, and membership is non-negotiable." She consulted her clipboard with theatrical precision. "According to our records, this property has been in violation of membership requirements for over 3 years. The accumulated fees, fines, and penalties total $47,000, payable immediately." The audacity was breathtaking. This woman was essentially claiming that Cristiano owed her organization nearly $50,000 for the privilege of not joining their club. It was extortion disguised as community standards enforcement. "Miss Whitmore, I'll need to see documentation proving that this property is legally bound by HOA agreements. Property deed restrictions and covenants are matters of public record." "Documentation?" Karen's voice rose with indignation. "Young man, I am the HOA president, and my authority doesn't require your approval. This property is subject to community standards, whether you acknowledge them or not." That's when Cristiano appeared in the doorway, wearing workout clothes and looking like he'd rather be literally anywhere else than dealing with suburban bureaucracy on his day off. His presence immediately shifted Karen's demeanor from aggressive authority to starstruck intimidation mixed with opportunistic calculation. "Oh my goodness," she breathed, apparently recognizing one of the most famous athletes in the world. "You're Cristiano Ronaldo." "Yes," he replied with the patient politeness of someone who dealt with this reaction thousands of times. "And you are bothering my staff about something?" Karen recovered her composure with impressive speed. "Mr. Ronaldo, I'm Karen Whitmore, president of the Crystal Lake HOA. I'm here to welcome you to our community and discuss your membership obligations." Cristiano looked at me with the expression of someone who dealt with enough business negotiations to recognize when someone was trying to sell him something he didn't need. "Jordan, what membership obligations?" "According to Ms. Whitmore, this property is supposedly subject to HOA requirements that weren't disclosed during purchase. She claims we owe $47,000 in fees and penalties." Cristiano's eyebrows rose with the kind of skeptical amusement reserved for people making obviously ridiculous claims. $47,000 for what exactly? Karen launched into what sounded like a rehearsed presentation about community standards, property maintenance requirements, and the benefits of organized neighborhood governance. Her pitch included everything from coordinated landscaping to security patrols to social events designed to bring the lakefront community together. Mr. Ronaldo, as someone of your stature, I'm sure you appreciate the importance of maintaining property values through consistent community standards. The Crystal Lake HOA ensures that our neighborhood remains exclusive and well-maintained. The irony wasn't lost on me. She was trying to convince the owner of multiple luxury properties worldwide that he needed her help maintaining real estate values. It was like trying to sell ice to an Eskimo if the Eskimo happened to be worth several $100 million. Miss Whitmore, Cristiano said with diplomatic calm, I appreciate your community involvement, but this property was purchased with full legal review. If there were HOA requirements, they would have been disclosed during the transaction. Karen's confidence never wavered. Mr. Ronaldo, community membership isn't optional in areas subject to HOA governance. The previous owner's failure to maintain membership doesn't exempt current ownership from community obligations. That's when I realized we were dealing with someone who either fundamentally misunderstood property law or was deliberately trying to defraud new property owners through intimidation and false claims of authority. Whitmore, I'm going to need you to provide legal documentation supporting your claims. HOA authority requires recorded covenants and deed restrictions that would have been disclosed during property transfer. Her reaction was immediate and telling. Instead of producing documentation, she became defensive and aggressive. Mr. Mitchell, I don't need to prove anything to you. The Crystal Lake HOA has governed this community for over 20 years, and our authority is established through consistent enforcement and community recognition. Translation: she had no legal documentation and was hoping we'd pay up rather than fight what appeared to be illegitimate claims of authority over property she had no right to control. Cristiano, meanwhile, was studying Karen with the analytical focus he usually reserved for opposing team strategies. Mr. Whitmore, who exactly do you think owns this property? According to our records, it's owned by some kind of trust or corporate entity. But ownership structure doesn't matter. All properties in our jurisdiction are subject to community standards. I exchanged a look with Cristiano that communicated months of working together. He nodded slightly, giving me permission to handle what was about to become a very uncomfortable conversation for Karen Whitmore. Whitmore, I said, pulling out my phone to access the property management files, I think we need to clarify something important about property ownership in this area. There's nothing to clarify, she insisted. The Crystal Lake HOA has authority over all lakefront properties, and compliance isn't optional. Actually, I continued, scrolling through digital documents, I think you'll find the ownership structure very interesting, especially since it appears you might be personally affected by any property management decisions. Karen's confident authority faltered slightly. What do you mean personally affected? That's when I pulled up the property records that would change everything. The Crystal Lake area wasn't just Cristiano's retreat location, it was his investment property portfolio. And according to the documentation I was looking at, he didn't just own his own lake house. He owned Karen's house too. Whitmore, I said, watching her expression carefully. What's your home address? 1247 Crystal Lake Drive, she replied automatically, then paused as something in my tone registered. Why? I showed her the property record on my phone screen. Because according to these documents, 1247 Crystal Lake Drive is owned by the same trust entity that owns this property, which means Cristiano Ronaldo isn't just your neighbor who refuses to join your HOA. Her face went through several interesting color changes as the implications hit her. He's your landlord. The silence that followed my revelation lasted approximately 30 seconds, but it felt like watching someone's entire worldview collapse in slow motion. Karen stared at my phone screen, showing the property records, her mouth opening and closing like a fish gasping for water, while her brain struggled to process that the person she'd been trying to intimidate with HOA authority was actually the person who controlled whether she had a roof over her head. That's not possible, she finally managed, her voice lacking the confident authority she'd wielded just moments earlier. I own my house. I've been paying a mortgage for 4 years. You've been paying rent, I corrected gently. The property was purchased by Ronaldo's investment trust in 2019 and has been managed through a property management company. Your monthly payments go to them, but the actual ownership belongs to the trust. Cristiano, meanwhile, was watching this exchange with the fascination of someone witnessing a real-time demonstration of how quickly arrogance can transform into panic. Jordan, how many properties do we own in this area? I pulled up the complete portfolio on my tablet. 17 properties around Crystal Lake, including the entire lakefront section where Ms. Whitmore's house is located. It's part of your North American residential investment strategy. The scope of Cristiano's property ownership in the area was clearly news to Karen, whose face was cycling through colors that don't exist in nature. She'd spent the morning trying to assert HOA authority over someone who literally owned the ground she stood on, her house, and most of her neighbors' houses as well. This is some kind of mistake, Karen insisted, but her voice lacked conviction. Property management companies handle rentals, not ownership transfers. I would have been notified if my ownership status changed. Ms. Whitmore, the property was purchased from the previous owner, who was apparently renting it to you under a lease-to-own arrangement that wasn't completed. When the trust acquired the property, your lease transferred to the new ownership entity. I showed her the relevant documentation on my tablet. According to these records, you've been notified multiple times about the ownership change and lease modification, but you apparently ignored the communications because they came from the property management company rather than directly from the owner. Karen's clipboard was trembling in her hands as she processed the implications of what she'd just learned. The woman who'd spent the morning demanding that Cristiano pay $47,000 in HOA fees was actually his tenant, subject to lease terms he controlled and eviction procedures he could initiate. Even if that's true, she said desperately, it doesn't change the fact that all properties in this area are subject to Crystal Lake HOA governance. Ownership structure doesn't matter for community standards compliance. Cristiano stepped forward with the kind of diplomatic smile he used for hostile journalists and difficult business negotiations. Ms. Whitmore, I think we need to clarify something important about this HOA you represent. There's nothing to clarify, Karen replied, though her voice was shaking. The Crystal Lake HOA has governed this community for 20 years. Jordan, Cristiano said, could you pull up the research our attorneys did on local property restrictions when we acquired these investments? I accessed the legal due diligence files that had been prepared during the property acquisitions. The information they contained was going to make Karen's morning significantly worse. According to the legal research conducted during property acquisition, there is no legally established HOA governing the Crystal Lake area. Whitmore references appears to be an informal social organization with no legal authority over property use or ownership. Karen's face went ashen. That's not true. We have bylaws, elected officers, and established community standards. Having bylaws doesn't create legal authority over other people's property, I explained. HOA governance requires recorded covenants and deed restrictions that bind all property owners. Without those legal instruments, your organization is essentially a social club with no enforceable authority. Cristiano was studying Karen with the analytical focus of someone who dealt with enough contract negotiations to recognize when someone was bluffing with no cards. Whitmore, are you telling me that you've been collecting fees and fines from residents without any legal authority to do so? We have community support and voluntary compliance, she insisted, but her confidence was evaporating like morning mist. Voluntary compliance doesn't justify demanding $47,000 from people who never agreed to join your organization, I pointed out. What you're describing sounds like fraud rather than legitimate community governance. That's when Karen made the mistake that would define the rest of her morning. Instead of acknowledging the problem and trying to find a reasonable solution, she doubled down on her claims with the desperation of someone watching their authority collapse in real time. Mr. Ronaldo, I don't care what your lawyers say or what your property records show. The Crystal Lake community has standards, and I won't allow residents to ignore their responsibilities just because they're celebrities. The threat was implicit but clear. Even though she'd just learned that Cristiano was her landlord and that her HOA had no legal authority, she was still trying to assert control through intimidation and public pressure. Cristiano's diplomatic smile became slightly sharper. Miss Whitmore, I want to make sure I understand your position correctly. You're telling me that despite being my tenant and despite your organization having no legal authority over my property, you intend to continue demanding compliance with requirements that have no basis in law. Community standards aren't subject to legal technicalities, Karen declared, apparently believing that moral authority could overcome property law and landlord-tenant relationships. I pulled out my phone to document what was happening because I had a feeling this conversation was about to take a turn that would require legal evidence. Miss Whitmore, you're currently standing on property owned by Mr. Ronaldo, making demands for money you have no legal right to collect, while threatening consequences you have no authority to enforce. Do you understand how that might be interpreted legally? Are you threatening me? She asked, her voice rising with indignation. I'm explaining the legal reality of your situation, I replied calmly. You're making demands for payment based on false claims of authority, while threatening someone who has actual legal power over your housing situation. That's when Karen played what she apparently thought was her trump card. She pulled out her phone with the dramatic flair of someone who believed that speed dial to authorities was the ultimate power move. "I'm calling the police to report harassment and intimidation by celebrity tenants who think money exempts them from community responsibility." "Please do," Cristiano said, his tone suggesting he was actually looking forward to the conversation. "I'd be very interested to hear how law enforcement interprets demands for $47,000 in fees from an organization with no legal authority." As Karen dialed, I realized we were about to witness something remarkable, a person so committed to their delusions of authority that they would call the police on their own landlord for refusing to pay imaginary fees to a fake HOA. The conversation that followed would become legendary in property management circles, but not for the reasons Karen expected. 911 Emergency Services, came the voice from her phone's speaker. "I need to report harassment and intimidation," Karen announced loudly enough for all of us to hear. "I'm being threatened by residents who refuse to comply with community standards." "Ma'am, is this an active emergency requiring immediate police response?" "Yes, I'm being verbally attacked for trying to enforce legitimate HOA requirements." "Ma'am, civil disputes regarding HOA matters are typically handled through civil courts rather than emergency police response." "Are you in immediate physical danger?" Karen's frustration was obvious. "They're threatening me with eviction and legal action just because I'm trying to maintain community standards." There was a pause on the line. "Ma'am, did you say eviction? Are you reporting a landlord-tenant dispute?" "No, I'm reporting harassment by someone who thinks celebrity status exempts them from HOA compliance." "Ma'am, I'm confused. Are you the property owner or the tenant in this situation?" That's when Karen realized she just told 911 that her landlord was threatening eviction while she was standing on his property demanding money he didn't owe to an organization that had no legal authority. The silence that followed was golden. "Ma'am, are you still there?" I need to call back," Karen said quietly, ending the call. Cristiano looked at me with barely contained amusement. "Jordan, I think we need to schedule a meeting with our property management attorney to discuss lease compliance and community relations in our Crystal Lake portfolio." "Absolutely," I agreed, "and perhaps we should review the rental agreements for all our tenants to ensure they understand the actual legal frameworks governing their housing situations." Karen was backing away from the door with the expression of someone who just realized they'd declared war on someone with significantly superior firepower. "This conversation isn't over," she said weakly. "Actually," Cristiano replied, "I think it's just beginning. Jordan, please contact our legal team about reviewing lease compliance for all Crystal Lake properties, and send a copy of today's conversation to the attorneys handling our property management issues." As Karen retreated toward her car, still wearing her tennis outfit and clutching her now meaningless clipboard, I realized we'd witnessed something remarkable: the complete collapse of false authority when confronted with actual legal power and property ownership. Sometimes the best way to handle people who abuse imaginary authority is to remind them of real authority. And sometimes justice comes through the simple recognition that landlords have rights that fake HOAs can't override. Karen Whitmore had just learned that demanding money from your own landlord based on non-existent authority was a really bad business decision. The rest of her day was going to get significantly worse. By Monday morning, news of Karen's confrontation with Cristiano had spread through the Crystal Lake community faster than wildfire through dry brush. I arrived at the property to find my phone buzzing with calls from other tenants in Ronaldo's rental portfolio, each one wanting to discuss their own experiences with Karen's fake HOA demands and questionable authority claims. The first call came from Dr. Sarah Chen, who rented the house 3 doors down from Karen's place. Her voice carried the kind of controlled anger that comes from someone who'd been professionally manipulated for months. "Mr. Mitchell, I need to talk to you about Karen Whitmore and the fees she's been collecting from residents. After hearing about Saturday's incident, I realized I may have been defrauded." "Dr. Chen, what kind of fees has Karen been collecting?" "Over the past 2 years, she's collected approximately $8,000 from me for what she called mandatory HOA dues, community improvement assessments, and violation fines. I paid because I thought it was legitimate, but now I'm wondering if any of it was legal." The pattern was becoming clear. Karen hadn't just been trying to intimidate Cristiano into joining her fake organization. She'd been systematically collecting money from tenants throughout the community by claiming authority she didn't possess over properties she didn't control. I scheduled meetings with Dr. Chen and 4 other tenants who'd contacted me about Karen's fee collection activities. What emerged was a picture of systematic fraud that had been going on for over 2 years, with Karen collecting thousands of dollars from renters who believed they were required to comply with legitimate community governance. Mrs. Helen Rodriguez, an elderly woman who rented the house closest to the lake, provided documentation that showed the scope of Karen's operation. She collected $3,200 from me last year for emergency community improvements and violation penalties. I paid because she said non-compliance would result in eviction proceedings. The threat of eviction was particularly manipulative because Karen knew these were rental properties where tenants had legitimate concerns about losing their housing. She'd used people's vulnerability to extract money for an organization that had no legal authority and no right to collect fees from anyone. Rodriguez, did Karen provide any documentation showing that these fees were authorized by the property owner or required by law? She said the landlord had delegated HOA enforcement authority to the community association. She had official-looking forms and everything. Official-looking forms that were apparently fabricated to support her fraud operation. Karen hadn't just been running a fake HOA. She'd been creating false documentation to make her fee collection appear legitimate to vulnerable tenants. When I briefed Cristiano on what I'd discovered, his reaction was immediate and decisive. "Jordan, we need to contact law enforcement immediately. What Karen's been doing isn't just harassment, it's systematic fraud targeting our tenants." The scope of potential criminal activity was staggering. Based on the preliminary information from just 5 tenants, Karen had collected over $20,000 in fraudulent fees over 2 years. If the pattern extended to other properties in the community, the total fraud amount could be significantly higher. I contacted Detective Brian Murphy with the El Dorado County Sheriff's Department to report suspected fraud activities targeting rental property tenants. Detective Murphy's response suggested that Karen's fake HOA operation wasn't the first of its kind he'd encountered. "Mr. Mitchell, we've seen similar cases where people create fictional community organizations to collect fees from residents who don't understand the legal requirements. It's a growing problem in areas with high rental property concentrations." "Detective, what kind of charges would Karen be facing if the fraud allegations are confirmed?" "Grand theft, fraud, impersonation of authority, and potentially organized criminal enterprise if she's been doing this systematically. We're talking about felony charges that could result in significant prison time." That afternoon, I met with the affected tenants to coordinate their complaints and ensure that law enforcement had complete documentation of Karen's fraudulent activities. The meeting took place at Cristiano's house, where the irony of gathering Karen's victims on her landlord's property wasn't lost on anyone. Dr. Chen brought financial records showing payments to Karen's Crystal Lake HOA that totaled $8,400 over 18 months. She was very professional about it. Official letterhead, detailed invoices, even payment plans for people who couldn't afford the full amounts immediately. The professionalism was what made Karen's operation particularly insidious. She hadn't been running some amateur scam. She'd created a sophisticated fraud enterprise that convinced educated, successful people to hand over thousands of dollars for services and authority that didn't exist. Mrs. Rodriguez provided copies of violation notices Karen had issued for infractions like inappropriate window treatments, non-compliant lawn maintenance, and unauthorized exterior decorations. Each violation came with fines ranging from $200 to $500, all payable to the Crystal Lake HOA. "The worst part," Mrs. Rodriguez said, "is that she made us feel like we were bad neighbors for questioning her authority." She said people who didn't support community standards were selfish and antisocial. The psychological manipulation was as sophisticated as the financial fraud. Karen had used shame, social pressure, and threats to create compliance among people who might have otherwise questioned her authority. Tom Bradley, who rented a house on the opposite side of the lake, brought documentation that revealed another layer of Karen's operation. She wasn't just collecting fees for violations and dues, she was charging residents for community services that never existed. What kind of services? Security patrols, landscape maintenance, community event planning, emergency response coordination. I paid $1,200 last year for enhanced security services that I never saw any evidence of. Karen had essentially been selling community services that existed only on paper, collecting money for programs that were never implemented while maintaining the appearance of legitimate community management. As we compiled the evidence, a disturbing picture emerged of systematic fraud that had been targeting vulnerable tenants for years. Karen's fake HOA had been a sophisticated criminal enterprise disguised as community service, extracting thousands of dollars from people who trusted her fabricated authority. The meeting was interrupted by the arrival of Detective Murphy, who'd come to take formal statements from the affected tenants and begin building a criminal case against Karen. His first question set the tone for what would become a comprehensive fraud investigation. Ladies and gentlemen, I understand you've all been paying fees to someone claiming to represent a homeowners association. Did any of you receive documentation proving that this organization had legal authority to collect money from rental property tenants? The unanimous answer was no. Karen had collected over $25,000 from just the tenants at our meeting, and none of them had been provided with evidence that her organization had any legal standing or authority to demand compliance or payment. Detective Murphy, Dr. Chen asked, "What happens to the money we paid? Can we get restitution?" Restitution is typically part of criminal sentences in fraud cases, but recovery depends on the defendant's assets and ability to pay. We'll be working with the district attorney's office to ensure that victims receive whatever compensation is possible. As Detective Murphy conducted individual interviews with each affected tenant, I realized that Karen's confrontation with Cristiano had done more than expose her lack of authority over his property. It had triggered an investigation that would uncover a multi-year criminal enterprise targeting vulnerable renters throughout the Crystal Lake community. The woman who demanded $47,000 from Cristiano for joining her fake HOA had been systematically defrauding tenants for years, using manufactured authority and fabricated documentation to extract money from people who trusted her claims of community leadership. By evening, Detective Murphy had completed his preliminary investigation and confirmed that Karen would be facing felony fraud charges that could result in several years in state prison. The fake HOA operation that had started as community overreach had evolved into systematic criminal enterprise. As I briefed Cristiano on the day's developments, he shook his head with obvious disgust. "Jordan, she wasn't just trying to scam us, she was preying on vulnerable renters who thought they had to comply with her demands or risk losing their homes." "The psychology is particularly manipulative," I agreed. "She used people's legitimate concerns about housing security to extract money for services and authority that never existed." The investigation would continue for weeks, but Karen's days of running a fake HOA to defraud tenants were over. Sometimes justice comes through criminal prosecution and victim advocacy. Sometimes it comes through landlords who understand their legal responsibilities to protect tenants from fraud and exploitation. Karen Whitmore had spent 2 years believing she could collect money from rental property tenants by claiming authority she didn't possess. Law enforcement was about to prove her very wrong. Wednesday morning brought the kind of law enforcement activity that transforms quiet lakefront communities into crime scenes. I watched from Cristiano's kitchen window as Detective Murphy and 3 other officers approached Karen's house with arrest warrants and search warrants that would dismantle her fraudulent HOA operation once and for all. The arrest was swift and professional. Karen emerged from her house wearing her usual white tennis outfit, apparently preparing for another day of intimidating neighbors, when Detective Murphy intercepted her with handcuffs and a Miranda warning that would change the rest of her life. "Karen Whitmore, you're under arrest for grand theft, fraud, and criminal impersonation of authority. You have the right to remain silent." From our vantage point across the lake, we could see Karen's reaction even at a distance. Her confident posture collapsed completely as she realized that her fake HOA operation had evolved from community harassment into felony criminal charges that carried serious prison time. Detective Murphy called me an hour later with an update that revealed the true scope of Karen's criminal enterprise. "Mr. Mitchell, the search of her residence revealed evidence of systematic fraud extending beyond what we initially suspected. We found records indicating she's been running similar operations in 3 other communities over the past 5 years. The implications were staggering. Karen hadn't just been defrauding tenants at Crystal Lake, she'd been operating a mobile fraud enterprise that targeted rental communities across Northern California. Her fake HOA scam was apparently a refined criminal operation that she'd perfected through years of practice. Detective Murphy, how much money are we talking about in total? Based on the financial records we seized, approximately $180,000 over 5 years. She's been systematically targeting rental properties where tenants are vulnerable to claims about community compliance and eviction threats. Karen had essentially been running a criminal enterprise that exploited people's legitimate concerns about housing security to extract money for services and authority that never existed. The sophistication of her operations suggested this was her primary source of income, rather than a side hustle gone wrong. That afternoon, I met with Cristiano and our legal team to discuss the implications of Karen's arrest for our property management operations. Attorney Rachel Harrison, who specialized in landlord-tenant law, explained how Karen's fraud activities had created liability issues for property owners. Mr. Ronaldo, when tenants are defrauded by someone claiming authority over rental properties, landlords can face legal exposure if they fail to protect their tenants from such exploitation. The fact that Ms. Whitmore was collecting money from your tenants while claiming community authority creates potential civil liability. What kind of liability are we looking at? Cristiano asked. If tenants can demonstrate that you knew or should have known about the fraudulent fee collection, they might have claims for restitution and damages. However, your quick action to investigate and coordinate with law enforcement should limit your exposure significantly. The legal complexities were substantial, but our proactive response to Karen's fraud operation had positioned us well for any civil litigation that might emerge from her criminal activities. Meanwhile, the criminal case against Karen was developing rapidly. District Attorney Patricia Kim announced that her office would be pursuing maximum penalties for what she called systematic exploitation of vulnerable renters through fraudulent community authority claims. Mrs. Whitmore used fabricated documentation and false claims of legal authority to extract thousands of dollars from people who trusted her representations about community compliance, DA Kim explained at a press conference. This type of fraud targeting rental property tenants represents a particularly predatory form of criminal activity. The charges Karen faced were extensive: multiple counts of grand theft, fraud, criminal impersonation of authority, and organized criminal enterprise. If convicted on all counts, she was looking at 8 to 12 years in state prison plus restitution to all identified victims. But Karen's legal troubles were just beginning. As news of her arrest spread through the communities where she'd operated, more victims came forward with reports of fraudulent fee collection and fake HOA enforcement activities. The Placer County District Attorney's Office announced they were opening parallel investigations into Karen's activities in Auburn and Grass Valley, where she'd apparently run similar fake HOA operations before relocating to Crystal Lake. Ms. Whitmore appears to have been operating a mobile fraud enterprise that targeted different rental communities sequentially, said Placer County DA Robert Chen. We're coordinating with other jurisdictions to ensure that all victims receive justice and that she faces appropriate consequences for the full scope of her criminal activities. The multi-jurisdictional investigation revealed a pattern that was both sophisticated and predatory. Karen would identify rental communities with high tenant turnover, establish herself as a community leader through volunteer activities, then gradually introduce fraudulent fee collection and enforcement activities that exploited people's unfamiliarity with local governance structures. Dr. Sarah Chen, who'd been one of Karen's primary victims at Crystal Lake, provided testimony that showed how carefully Karen had cultivated trust before beginning her exploitation. She spent months building relationships and establishing credibility before she started collecting fees. She made it seem like she was protecting property values and community standards. The psychological manipulation had been as sophisticated as the financial fraud. Karen had used legitimate community concerns about property maintenance and neighborhood safety to create acceptance for her fraudulent authority and fee collection activities. Rodriguez provided evidence that revealed another disturbing aspect of Karen's operation. She specifically targeted elderly residents and people who seemed financially vulnerable. She offered payment plans and reduced fees for people who couldn't afford the full amounts, which made her seem compassionate rather than predatory. The targeting of vulnerable populations elevated Karen's crimes from simple fraud to systematic exploitation that would likely result in enhanced sentencing under California's vulnerable victim statutes. As the investigation expanded, law enforcement discovered that Karen had been using sophisticated documentation to support her fraud operation: professional letterhead, official-looking forms, and fabricated legal references that would have convinced most people that her organization had legitimate authority. She wasn't running some amateur scam, Detective Murphy explained. This was a professional-grade fraud operation with systematic victim targeting, sophisticated documentation, and carefully planned psychological manipulation techniques. The bail hearing revealed the extent of Karen's flight risk and criminal history. Judge Maria Santos denied bail after prosecutors presented evidence that Karen had relocated multiple times to avoid detection and had no significant ties to the community beyond her fraudulent activities. The defendant appears to have been operating a mobile criminal enterprise designed specifically to exploit rental property tenants in different jurisdictions, Judge Santos noted. The pattern of behavior suggests significant flight risk and ongoing danger to community safety. Karen would remain in custody until trial, facing charges that could effectively end her criminal career and result in restitution obligations that would follow her for the rest of her life. As I briefed Cristiano on the legal developments, he shook his head with obvious disgust. Jordan, she wasn't just trying to intimidate us into joining her fake organization. She was systematically preying on vulnerable people who trusted her claims about community authority. The scope is remarkable, I agreed. She'd refined her operation through years of practice, targeting people who were least likely to have the resources or knowledge to challenge her authority. The criminal prosecution would continue for months, but Karen's days of exploiting rental communities through fake HOA operations were permanently over. Sometimes justice comes through victim advocacy and law enforcement coordination. Sometimes it comes through landlords who understand their responsibility to protect tenants from predatory exploitation. Karen Whitmore had spent 5 years believing she could build a criminal enterprise by exploiting people's trust in community authority. The criminal justice system was about to prove her catastrophically wrong. 4 months after Karen's arrest, I sat in the El Dorado County Superior Court, watching her defense attorney make what could only be described as the most desperate opening statement in recent legal memory. Karen sat at the defendant's table, wearing a county jail uniform that had replaced her signature tennis outfit. Her hands folded as her lawyer tried to convince a jury that systematic fraud was actually misunderstood community service. The trial had attracted significant media attention, not just because of Cristiano's celebrity status, but because Karen's case had become a symbol of how fake authority could be used to exploit vulnerable communities. Legal experts were calling it a landmark prosecution for rental property fraud, disguised as community governance. Superior Court Judge William Torres presided over proceedings with the kind of stern efficiency that suggested he'd reviewed the evidence and wasn't impressed by what he'd found. The courtroom was packed with victims, media representatives, and law enforcement officials who'd worked on the multi-jurisdictional investigation. Prosecutor Jennifer Walsh opened with a statement that set the tone for everything that would follow. Ladies and gentlemen of the jury, the defendant didn't just collect a few unauthorized fees. She spent 5 years building a criminal enterprise that systematically exploited vulnerable renters across multiple communities by claiming authority she never possessed. The prosecution's case was overwhelming. They presented evidence of Karen's operations across 4 communities, involving fraudulent fee collection from dozens of victims, fabricated documentation, and financial records showing $180,000 in criminal proceeds over 5 years. The first week of testimony focused on Karen's Crystal Lake operation. Dr. Sarah Chen described how Karen had gradually introduced fee collection after establishing trust through volunteer activities and community involvement. She spent months building credibility before she started demanding money, Dr. Chen testified. She made it seem like she was protecting property values and community standards, when actually she was just stealing from people who trusted her. Mrs. Rodriguez provided particularly damaging testimony about Karen's targeting of elderly and financially vulnerable residents. She offered payment plans and reduced fees for people who couldn't afford the full amounts. She made her exploitation seem like compassion. The defense strategy was predictably desperate. Attorney Robert Sterling argued that Karen's activities represented legitimate community leadership that had been criminalized by overzealous prosecutors who didn't understand HOA governance. My client was a dedicated volunteer who worked tirelessly to maintain community standards, Sterling argued. Any fees collected were voluntary contributions for legitimate community services. The argument collapsed under cross-examination when Prosecutor Walsh presented Karen's fabricated documentation, her systematic victim targeting, and financial records showing how she'd laundered criminal proceeds through multiple accounts. Mr. Sterling, Prosecutor Walsh said during cross-examination of Sterling's expert witness, can you point to any legal authority that allows community volunteers to collect thousands of dollars in fees from rental property tenants without owner authorization or legal standing? The expert witness, a former HOA management consultant, was forced to admit that no such authority existed under any interpretation of community governance law. But the trial's most dramatic moment came when Cristiano testified about Karen's confrontation at his property. His testimony was calm and professional, but the impact on the jury was obvious when they heard how Karen had demanded $47,000 from her own landlord while threatening consequences she had no authority to impose. She was standing on property I owned, demanding money for an organization that had no legal authority, while threatening someone who had actual legal power over her housing situation, Cristiano explained. The audacity was remarkable. The financial evidence presented by forensic accountants showed that Karen had been living entirely off criminal proceeds while maintaining the appearance of being a community volunteer. She had no legitimate income sources during the periods when she was collecting fraudulent fees from victims. The defendant's lifestyle was funded entirely by theft from vulnerable renters, Prosecutor Walsh explained during closing arguments. She turned community service into personal enrichment and civic responsibility into criminal opportunity. Karen's reaction throughout the trial showed someone who'd finally realized the scope of her legal exposure. She sat mostly motionless at the defense table, occasionally whispering to her attorney, but generally staring at evidence displays that documented 5 years of systematic fraud with professional thoroughness. The victim impact testimony was devastating. 12 victims from 4 different communities described how Karen's fraud had affected their finances, housing security, and trust in community institutions. Several elderly victims testified about the lasting psychological impact of being manipulated by someone they'd trusted as a community leader. "She made us feel like bad neighbors for questioning her authority," testified Margaret Foster, an 78-year-old victim from Auburn. "She used our desire to be good community members as a weapon against us." The psychological manipulation had been as sophisticated as the financial fraud. Karen had systematically exploited people's legitimate concerns about community relations and housing security to extract money for services that never existed. Defense attorney Sterling's closing argument was a last-ditch attempt to portray Karen as someone whose community dedication had been misunderstood by prosecutors who criminalized legitimate governance activities. Sterling argued that her fee collection represented voluntary community support rather than criminal fraud. The jury deliberated for exactly 3 hours and 42 minutes. "Guilty on all counts," the foreman announced, his voice carrying clearly through the packed courtroom. Karen's reaction was immediate and devastating. She collapsed forward at the defense table, her body shaking with the kind of sobs that come from someone who'd finally realized that 5 years of criminal activity had destroyed her life permanently. Judge Torres scheduled sentencing for 6 weeks later, but his immediate comments suggested Karen would be facing maximum penalties under state fraud statutes. "Ms. Whitmore, you systematically exploited vulnerable members of multiple communities by claiming authority you never possessed and collecting money for services that never existed. Your crimes represent not just theft, but a fundamental betrayal of the trust that makes community life possible." Outside the courthouse, the media response was immediate and comprehensive. Legal experts called the conviction a watershed moment for rental property protection and community accountability. Victim advocates celebrated what they called long overdue justice for systematic exploitation of vulnerable renters. Cristiano's statement to reporters captured the broader significance of the case. This trial proved that no one can use fake authority to exploit people's trust and vulnerability. Karen Whitmore spent years stealing from people who believed she was protecting their communities, and today justice held her accountable. The victim impact extended far beyond the immediate financial losses. Residents from 4 communities had testified about lasting psychological effects of discovering that their trusted community leader had been systematically defrauding them. Dr. Chen spoke to reporters about the relief of seeing justice served. "For years, Karen made us question our own judgment and feel guilty for not supporting community standards. Today we learned that the problem wasn't our skepticism, it was her criminal exploitation of our trust." As the trial concluded, I reflected on how Karen's confrontation with Cristiano had uncovered one of the most sophisticated rental property fraud enterprises in recent memory. What started as her demand for bogus HOA fees had exposed systematic criminal operations that had victimized dozens of families across multiple communities. The sentencing hearing would determine how many years Karen would spend in state prison, but her days of exploiting community trust for criminal gain were permanently over. The communities she'd targeted were implementing protections designed to prevent similar exploitation, and law enforcement agencies were using her case as a template for identifying and prosecuting comparable operations. Sometimes justice comes through victim courage and law enforcement coordination. Sometimes it comes through landlords who understand their responsibility to protect tenants from exploitation. And sometimes it comes through the simple recognition that community trust is precious and people who violate it for personal gain deserve serious consequences. Karen Whitmore had spent 5 years believing that fake authority could shield her from accountability for systematic fraud. The jury's verdict had proven her catastrophically wrong. 6 weeks after the verdict, I sat in the same courthouse where Karen's conviction had made statewide headlines, watching Judge William Torres deliver a sentence that would reverberate through rental property management across California. Karen appeared at the defendant's table wearing the same orange jail uniform. But something fundamental had changed. The manipulative confidence that had defined her interactions with vulnerable tenants had been replaced by the hollow expression of someone who'd finally understood the permanent consequences of 5 years of systematic fraud. The sentencing hearing had drawn representatives from tenant advocacy organizations, property management associations, and law enforcement agencies from multiple counties. The case had become a symbol of how predators could exploit rental communities through fake authority and its resolution would set precedents for protecting vulnerable tenants nationwide. Judge Torres opened the proceedings with comments that would be quoted in legal journals and tenant protection seminars for years to come. Ms. Whitmore, you didn't just steal money from individual victims. You systematically exploited the trust that makes rental communities possible, turning community leadership into a weapon against the very people who needed protection most. The victim impact statements were devastating. 12 victims from 4 communities testified about lasting psychological trauma and financial hardship caused by Karen's systematic fraud. Mrs. Margaret Foster, the 78-year-old Auburn victim, used a walker to approach the podium but spoke with clear determination. Your Honor, Karen didn't just steal my money. She stole my ability to trust community leaders and made me question my own judgment for years. The psychological damage has been harder to recover from than the financial losses. Dr. Sarah Chen focused her statement on the broader implications of Karen's crimes for rental community safety. Your Honor, this case isn't just about one person's criminal behavior. It's about the systematic exploitation of people who trusted someone claiming community authority. Karen's crimes have made it harder for legitimate community leaders to earn trust and for tenants to feel safe in their own neighborhoods. Cristiano's victim impact statement, delivered via video conference from his training facility in Europe, captured the property management perspective on Karen's fraud operation. Your Honor, as a property owner, I have responsibilities to protect my tenants from exploitation and fraud. Karen's systematic targeting of rental communities represents a particularly predatory form of criminal activity that threatens the basic safety and security that tenants deserve. The federal sentencing guidelines for organized fraud, combined with the multi-jurisdictional scope and vulnerable victim targeting, resulted in a sentence that would effectively end Karen's criminal career permanently. Judge Torres sentenced Karen to 11 years in state prison, followed by 5 years supervised probation with permanent restrictions on any community leadership activities. Ms. Whitmore, your crimes spanned 5 years, 4 communities, and dozens of victims. You used fabricated authority to systematically exploit people who trusted you as a community leader. This sentence reflects not just punishment for past crimes, but protection for future communities from similar predatory exploitation. Karen's reaction was immediate and complete. She collapsed forward at the defense table, her entire body shaking as she finally grasped that her criminal enterprise had destroyed her life permanently. At 35 years old, she would spend most of her remaining productive years in state custody. The restitution order was comprehensive, requiring Karen to pay $180,000 to identified victims plus additional penalties and fees. Her prison wages and any future assets would be garnished to compensate the communities and individuals she'd victimized. But the impact extended far beyond Karen's personal destruction. Her case had triggered the most comprehensive reform of rental property protection in California history, with new state requirements for tenant education, fraud reporting, and landlord accountability that would protect renters from similar exploitation. Attorney General Patricia Morrison announced at a post-sentencing press conference that Karen's prosecution had become a template for identifying and prosecuting rental property fraud nationwide. Ms. Whitmore's case has fundamentally changed how we understand the intersection of community leadership and criminal opportunity targeting vulnerable tenants. The investigation had ultimately identified 47 victims across 4 counties, with total documented losses exceeding $200,000 when including costs for legal representation and credit repair. The scope of victimization had triggered federal attention to rental property fraud as a growing threat to housing security. The California Tenant Protection Act, passed in response to Karen's case, established mandatory reporting requirements for suspected community fraud, enhanced penalties for crimes targeting rental property residents, and funding for tenant education programs about legitimate versus fraudulent community authority. Crystal Lake had been transformed from a community terrorized by fraudulent fee collection into a model of transparent property management and tenant protection. Property values had actually increased as families specifically sought out rental communities with strong anti-fraud protections and ethical management practices. Mrs. Rodriguez, who discovered she'd paid over $3,000 in fraudulent fees to Karen's fake HOA, had become a statewide advocate for tenant protection. What happened in our community could happen anywhere that people assume someone claiming community authority is automatically legitimate, she told a state legislative hearing on rental property fraud. The annual California Rental Property Safety Conference, established in response to Karen's case, brought together law enforcement, legal experts, property managers, and tenant advocates to discuss preventing similar exploitation of rental communities. Karen's case featured prominently as a primary example of how sophisticated predators could exploit community trust for systematic criminal enterprise. Cristiano's property management company had expanded to focus specifically on tenant protection and community fraud prevention. The most dangerous criminals are often the ones who hide behind fabricated authority and prey on people's legitimate desires for safe, well-managed communities, he explained to property managers learning to identify and prevent similar exploitation. 2 years after sentencing, I received a letter from the state prison where Karen was serving her sentence. The envelope was thin, the handwriting uncertain, and the message was brief. I finally understand what community leadership was supposed to mean. I'm sorry it took destroying so many lives to learn that lesson. I showed the letter to Cristiano during one of his visits to the Crystal Lake property. He read it with the expression of someone who'd found closure he didn't know he needed. Do you think she actually learned something from this? Hard to say, but I hope so. The woman who wrote that letter sounds different from the one who demanded $47,000 from her own landlord for joining a fake organization that had no legal authority. Are you going to respond? Cristiano thought about it for a long moment. No, some lessons come at too high a price for the people who had to teach them. Karen made her choices over 5 years of systematic fraud, and dozens of vulnerable people paid the price. That's something she'll have to live with, not something I need to forgive. 5 years after the trial, Karen's case had fundamentally changed rental property management across America. Her mugshot still appeared in training materials for property managers and tenant advocates, usually accompanied by detailed analysis of how fake community authority could be used to exploit vulnerable renters. The Whitmore Tenant Protection Standards, implemented by property management companies nationwide, established mandatory fraud reporting, tenant education requirements, and regular auditing procedures that made rental property fraud significantly more difficult to execute and easier to detect. The house where Karen had lived while defrauding her neighbors had been converted into the Crystal Lake Tenant Resource Center, where renters could access legal advice, fraud reporting assistance, and education about legitimate versus fraudulent community authority. The irony that her former home had become a center for protecting people from exactly the crimes she'd committed wasn't lost on anyone. But perhaps the most lasting impact was the cultural shift in how rental communities approached authority and accountability. Karen's case had proven that community positions carried real legal responsibilities, that tenants had rights that couldn't be violated by fraudulent exploitation of authority, and that systematic abuse of community trust would face serious criminal prosecution. From the lakefront property where Karen had first confronted Cristiano with demands for bogus HOA fees, I could see the community she'd tried to exploit through fake authority. Children played on beaches that were now protected by robust tenant advocacy programs. Elderly residents enjoyed community activities that were transparently funded and ethically managed. Young families rented homes in neighborhoods where community leadership meant service rather than exploitation. Sometimes justice is an 11-year prison sentence and $200,000 in restitution. Sometimes it's communities learning to protect themselves through education and transparency. Sometimes it's the recognition that real community leadership serves vulnerable people instead of preying on them. Karen Whitmore had tried to build a criminal empire by systematically exploiting people's trust in community authority and their legitimate concerns about housing security. Her downfall had created a nationwide movement for tenant protection, rental property accountability, and ethical community governance that would safeguard vulnerable renters for generations. The fraudulent fee demand had lasted 30 minutes. The criminal enterprise had spanned 5 years across 4 communities. The protections triggered by her prosecution would shield rental property tenants forever. Karen's story ended in a state prison cell. Her fake authority permanently stripped away and her criminal operations permanently dismantled. The story of the communities she'd victimized began with healing, reform, and the recognition that real leadership protects vulnerable people instead of exploiting them. The lake reflected the morning sunlight each day as I reviewed property management reports, a daily reminder that some communities recover from predatory exploitation by choosing transparency over deception, protection over profit, and justice over impunity. Justice had been served, communities had been protected, and Karen Whitmore's criminal legacy had become a cautionary tale that would safeguard future tenants from similar predators who mistook community service for criminal opportunity. The end of her story was imprisonment and permanent disgrace. The beginning of tenant protection was everything that came after.